First, I just wanted to mention thank you so much for being here for our final class of the virtual HOA Academy. Today's topics are going to be discussing Arizona's open meeting law and records requests by owners. We're going to give a quick COVID-19 update and some planning strategies for the rest of 2020.
This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Town of Queen Creek. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. Whether you're working from home or doing kindergarten from home, we want to remind you that we're in this together.
City of Tempe. We are in this together.
So let me just start by saying my name is Beth Mulcahy, and I'm the managing partner and senior attorney of the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed practicing community association law for the past 23 years, actually 24 years. I just had our firm's 24-year anniversary on Sunday. And my firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. In addition to representing many associations over the past 24 years, I also have served as a director and as president of my association. So I hope that I bring a unique perspective to these classes in that I have served on my board for many years. I had a little stint as a disgruntled owner in my community, so I understand what that feels like. And also I've worked for 24 years trying to make associations better and helping associations follow Arizona law regarding planned communities and condominiums. So welcome to the finale of our virtual fall HOA Academy in partnership with many different cities and towns throughout the state of Arizona. I'd like to give a special shout out and thank you to the many city and towns who have worked with us to collaborate to create this virtual HOA Academy this fall. The different cities that are participating and collaborating with our firm for this virtual HOA Academy are Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, Tempe, and the town of Queen Creek. And I can't tell you how happy I am to be partnering with these many different cities and towns to create free education for board members, managers, and homeowners who live in associations so that you can better run your associations and have fewer problems as you're navigating these challenging times. So first, I'd like to just start out. In case you've missed our previous classes, I'd like to just mention that you can see all of our previous classes. We have 4 other classes through our virtual HOA Academy that we've had this fall. And you can find all of those classes as recorded videos on my firm's website at mulcahylawfirm.com. Once you go to the homepage, all you need to do is click on the videos page, and a link will be posted in the comment section of this video to help you find that. We'd like to also just extend a big thank you to the wonderful representatives from Neighborhood Services from across the Valley for making this fall virtual academy a success and just making it happen. Right now, we're in the final planning stages of putting together our spring calendar of virtual classes, which is going to include collaborative seminars with neighborhood services departments, again, from around the Valley. And some of the different neighborhood services departments are also going to have individual classes, which we're going to help them do virtually. And so we're really excited to have you learn about those. We will be releasing the class dates, times, and topics sometime in the next 60 days. With Election Day today, we were going to talk a little bit about political signs and flags, and when's the end date for all of those signs and flags to be removed from properties and HOAs and condos. So we'll start out talking about that. I'm also going to give a quick COVID-19 update. We're going to talk about Arizona's open meeting law and virtual meetings, and we're going to talk about how to handle records requests from owners. What owners can and can't see, why typically do owners request to see records, and what are some good strategies that can help you to turn a records request into a win-win for the owner and for the association. I think we all can agree that we saw significantly larger number of political signs and political flags in associations this election season. And so with that, there'll be some new issues that will come up later this week. And the issues will be, of course, under Arizona law, owners are allowed to have political signs and political flags on their property. But there's an end date under Arizona law, and all of those signs and flags that are political in nature need to be removed from an owner's property by Saturday, November 7th, 2020. And so one just little tip I'd like to give associations is, or managers, if you're listening today, it might be a good idea to send out a reminder tomorrow, the day after the election, just reminding everybody that all the political signs and flags in your community need to be removed by Saturday, November 7th, 2020, and that is state law. The next thing I want to talk about is what's been going on with COVID-19. Fortunately, it has been relatively quiet in comparison to March, April, and May, when we had a lot of developments on COVID-19. But we have recently seen an uptick in the number of reported COVID-19 cases in Arizona. And in fact, last week, Governor Ducey held a news conference on October 29th and stated that there is a storm ahead of us and reminded Arizonans to continue to follow social distancing guidelines, wear a mask in public, and wash your hands often. And so this continues to be a concern for many associations, that we're working with and that have been reaching out to us during the pandemic to ask for advice on how their association can best navigate the pandemic. Some other kind of interesting things that the governor in Arizona, Governor Ducey, has announced in the past week or so. $1.6 million of state funds to expand food bank assistance and $7 million for housing and rental assistance just last week in Arizona. In addition, Arizona's Department of Economic Security has distributed more than $11 billion in unemployment benefits to Arizonans since the start of the pandemic. Just some factors that kind of are related to this that we want to have associations keep an eye on. A recent poll conducted by our firm where we had 200 board members, managers, and owners fill out a survey poll that we had indicated that the number of owners not paying assessments is increasing in associations. And so I'd just like to do a reminder to boards that it's important that you act quickly when owners become delinquent in your association. The sooner that you act on a delinquent assessment, the more likely you are to collect on that debt. So for example, if you're waiting a year or 6 months to contact an owner regarding a delinquency, you're less likely to collect the full amount of the delinquency or to work out a payment plan. So we would just like to encourage you to be reaching out to the owners if they are not paying their assessments in a timely manner, and making sure that you are following a collection plan for your association and turning the file over to your attorney to take legal action once it hits that certain point in your collection plan. Okay, I'm really happy to see now we have 46 people live watching us here today, and we're just doing our introductory remarks on COVID-19. So what can we expect in the next 2 months till the end of 2020? I, for one, can say that I'm going to be really happy when 2020 is on the books and we can move into 2021. It's been a stressful year for many managers and board members having to deal with these many restrictions that have been placed on associations and owners dealing with the restrictions from the state in Arizona as well. So what can we expect for the balance of 2020? I think we can anticipate, if we're watching some of the shutdowns in Europe and the uptick in the number of COVID cases in Arizona, there's a possibility of future closures for common areas. There's a possibility of more COVID cases in your association, increase in delinquencies, which I just talked about. You're going to have to possibly make future adjustments in your 2021 budget. I think you can expect that we're going to be having virtual meetings at least into the first, possibly the second quarter of 2021. So these are all things that are important things to keep an eye on for your associations. Our firm is going to continue to be carefully watching the governor's orders and any federal mandates that may pertain to Arizonans and associations in general. and any trends that we're seeing that might be helpful if we can give you advice on trends that we're seeing on how associations should be responding to these trends. And we'll continue to do this even though this is our last class for the fall Neighborhood Virtual HOA Academy. And how we'll do that is we'll continue to post information on Facebook. If necessary, we'll continue to conduct Facebook Lives. And don't forget to sign up for our law firm's email memos that we send out at least once or twice a month with updates on important things that you need to hear about. And you can sign up for that by going to our website at mulcahylawfirm.com. Okay, let's switch gears and talk about Arizona's open meeting law and how we should be conducting open meetings during the pandemic. Well, first, we want to start out by just mentioning we have a couple of cheat sheets that'll be really helpful for you today. Morgan in our office is posting them in our comments section. Right now, I think she's already posted one on collecting delinquent assessments and some secrets if you are seeing an uptick in delinquencies. As we start talking about open meeting laws, we're also going to be posting several cheat sheets that will help your associations follow the open meeting law in Arizona, have quicker board meetings, and also how to transition to virtual board meetings and have successful virtual board meetings. First, let's just start out by saying that Arizona has a special open meeting law just for condominiums and planned communities. And it's different than the open meeting law that applies to city council or school boards. We have a special one that's outlined in our specific laws in the Condominium Act and the Planned Communities Act. As a starting point, our firm continues to recommend that boards conduct virtual board meetings and committee meetings during this time. We know that some boards are starting to meet in person, and if you are doing that, please be mindful of having social distancing, keeping track of who's attending in case there has to be any tracing, contact tracing, making sure that people are wearing masks, making sure that people are, at least 6 feet apart, maybe taking their temperatures before they come into the meeting. All these things are important if you are starting to have in-person meetings. But again, we recommend that you continue doing the virtual meetings at least through the first quarter of 2021, mostly because it's successful, it's working. Many associations are easily transitioning to virtual meetings. The meetings are shorter. There seems to be less fighting and controversy at these meetings, which is a good thing for our industry, of course. And there's a lot of benefits to having the virtual meetings. So we're encouraging our boards to be safe and to continue having virtual meetings at least through the first quarter of 2021. Well, let's just start out with the nitty-gritty of what are the most important things you need to know about the open meeting law in Arizona. The first point I'd like to make is anytime you have a quorum of your board meeting to discuss association business, or anytime you have a regularly scheduled committee meeting, that meeting needs to be conducted as an open meeting. And what does that mean? It means that anytime you have a quorum of board present and you're discussing association business, members shall be permitted to attend and speak at an appropriate time during the deliberations and proceedings of the meeting. Now, a question I often get about, boards is if less than a quorum are meeting to discuss association matters, does it have to be an open meeting? So less than a quorum, no. If it's a quorum, yes, it must be an open meeting. Another question that we commonly get is, what about committee meetings? Our committee doesn't meet regularly. Does it have to be an open committee meeting? No, it doesn't. So what does it mean to meet regularly so that this law kicks in and you have to comply with it if you're a committee meeting? It would mean that you have like your architectural committee meeting once a quarter or once every month. But if you have sporadic, non-regular committee meetings, you aren't, in my opinion, required to comply with the open meeting law. But of course you can, and best practices would be if it's a committee that has a general interest factor for your association, you may want to be conducting it virtually or with proper social distancing in place, during the pandemic. Okay, so now you know a quorum of the board meeting to discuss association business must be an open meeting. How do we handle when we have residents attending? How do we handle keeping control of the meeting? So first, you can place reasonable time restrictions on those persons that are contributing, owners that are contributing during the meeting. And we've seen restrictions of a minute, 2 minutes, and there are going to be appropriate times when owners are allowed to contribute during the meeting. So typically most boards have what we call an open forum at the beginning of the meeting. And during that time, owners may be given 1 or 2 minutes to make any general comments that they'd like to before the meeting starts. In addition to that, the boards must allow owners to contribute before the board takes formal action on an item. And so what examples of that would be anytime the board is voting on an item. If an owner wants to talk during that time, the board, how it would work is somebody on the board makes a motion, and then somebody makes a second, and then there's discussion. During the discussion time period, if somebody in the audience, an owner, wants to talk, the board can allow that person to talk. We can put restrictions on how long they talk, and we can also just put a limit of a reasonable number of persons on each side of an issue to be able to talk during that time. Okay, what are some special considerations for virtual meetings to comply with the open meeting law? Well, first, if you're conducting your meetings using a platform such as Zoom, you can use the mute button during the regular board meeting so that only the board members are allowed to contribute during the board meeting. And then if an owner wants to contribute, of course, they can raise their hand, and during appropriate times during the meeting, the owners would be allowed to contribute. And like I said before, maybe you have a homeowner forum at the beginning, or maybe you're you have a homeowner that wants to talk before the board takes formal action on something. That would be the time to unmute them and allow them to contribute. A common concern that we have about having virtual meetings is some owners aren't tech savvy, and they aren't able to log on to Zoom to listen into the meeting. A couple of thoughts on that. Remember that Zoom has a number of different ways that you can connect to the call. Of course, you can do it on your smartphone, your iPad, your computer, and you can see everybody through the teleconferencing. Also, there's a phone number that anybody who has a phone, whether it's a smartphone or even a home line, they can call into the meeting and listen as long as they have the dial-in number and the special codes to get into the meeting. So recognize that maybe you just need to provide some additional feedback to owners on how they can listen in on a Zoom meeting if they're unable to. In some cases, you'll have owners, and we have this even at the association that I live in, where they just absolutely 100% refuse to participate in any virtual meetings. And they want us to go back to having in-person meetings. In those cases, what you can do is you can, on the Zoom function and many other platforms that have virtual meetings, you can record the meeting, and you can get out that recording of the meeting quickly. And you can encourage any owners that have questions to submit the questions before the meeting, and you can answer them during the Zoom meeting. Also, you can distribute draft meeting minutes before they're approved immediately after the board meeting to provide owners with a quick update as to what happened on the online platform. I just saw a question pop up, so I'm going to respond to it right away. Can people submit questions anonymously? I'm fine with that as long as the questions are appropriate and not offensive. I think that's fine. And boards should try to answer any questions that may be out there. Okay, let's talk a little bit more about the nitty-gritty of the open meeting law. Associations are required to give notice of the board meetings and regularly scheduled committee meetings. And we must do that by giving notice to the homeowners 48 hours in advance of the meeting. And this can be done by newsletter, conspicuous posting, putting on your website, or any other reasonable means, such as putting on a bulletin board at your association, or maybe having sandwich boards at the entrance of your community, or placing it on the bulletin board at the entrance of your community. Most of our clients now are sending out email blasts or posting the meeting notice, which indicates the date, time, purpose, and place of the meeting on the association's website. Now remember, if you're conducting your meetings virtually, the notice must also state that there's no physical location for the meeting and provide info on how to dial into the virtual meeting. So you'll have to give them the Zoom link or the Zoom passwords or any other information that they'll need to dial into that meeting. If you are going to have a meeting in person right now during the pandemic, you want to place any special recommendations and considerations on the meeting notice, indicating that owners will need to be socially distanced, at least 6 feet apart. They'll be required to wear masks. You may be taking their temperature, etc., so that everybody's aware of what the restrictions might be if you are having an in-person meeting. Another suggestion we'd like to give is place the notice and the agenda on the website, and place the agenda really whenever you put the notice anywhere else too, because that gives owners an opportunity to see what's going to be discussed at the meeting and determine whether or not they want to attend. Okay, let's talk a little bit about executive session. What is executive session? Executive session is when the board and maybe a special guest, such as the manager or the attorney for the association, or maybe an owner that's has a special concern and wants to talk with the board privately with the board. It's when the board meets privately without it being an open meeting to all residents to attend, and discusses certain categories of business. And typically what happens is under Arizona law, the board is required to announce just before the executive session starts what topics they're going to be discussing. And it has to be one of the 5 topics that are approved and allowable under Arizona law to have an executive session. And if you're just having an executive session and you're not having a board meeting along with the executive session, so for example, many of our clients have a board meeting, and then after the board meeting's over, they go into executive session, but occasionally you'll just have an executive session without a board meeting. So if you're doing an executive session without a board meeting, what we recommend to you is that you place on your notice, your meeting notice, and your agenda, what topics under the law you're going to be discussing during the executive session so that you meet that requirement under Arizona law. We also suggest you place that on a regular meeting agenda too, and indicate that you're going to be convening at the end of the meeting and going into executive session. Okay, so what are the most common executive session topics that our firm sees boards going into executive discussion to discuss? I would say number 1 would be advice from your attorney, and that advice could be maybe your attorney is coming to the Zoom call to provide it, or maybe your attorney did an opinion letter or an email, or maybe your manager or board member had a phone call with the attorney, and that advice is being relayed to the board during the executive session. So really, any time that you're getting legal advice from an attorney for the board or the association, that would be an appropriate time to go into executive session. The second most common category that we see are dealing with violations. So delinquencies, violations on a lot owners, such as not maintaining their property, or other issues that may pertain to the behavior of the owners or any residents that may be residing in the property. So enforcement issues is going to be the second most common topic. And then the third most common topic that we see is going to be dealing with issues pertaining to independent contractors or employees of the association. And that could be whether you're talking about their job performance or possibly any other aspect of how they're doing their job. Maybe things aren't going well, or maybe you're talking about a bonus during November, December to reward them for working hard throughout the year. Those typically are the most 3 common topics that we go into executive session for. But on our cheat sheet that we posted in our comment section, there's a more extensive list of 5 different topics. And the first one we already talked about. So these are the kind of the legal jargon of the 5 areas that you can go into executive session for. So legal advice from your attorney, pending or contemplated litigation. So anytime you're thinking about suing an owner or you're already involved in litigation. Anytime you're discussing the personal health or financial information about an individual member of the association or an independent contractor or an employee of the association. And again, matters pertaining to the job performance of, compensation of, health records of, or any complaints that you may have for your vendors for your association. And then last but not least, if you want to discuss a member's appeal of a violation or a citation or a penalty, like a fine that's levied against an owner, you can do that in executive session, unless the owner specifically asks that it be in the open session. So again, those are the topics that you can go into executive session for. Advice from your attorney, enforcement, violations, delinquencies, and talking about potential issues with your vendors. Those seem to be the most typical topics that boards go into executive session for. Just a word of caution and a reminder. Remember that if you're going into executive session and another non-executive session topic comes up, be really careful to not cross over to a non-executive session topic. What you'll want to do is either at the end of the executive session, go back into the open meeting and take minutes, or save it for next month's meeting. Okay, just a quick reminder on annual meetings, just a good time to talk about. As we're talking about open meetings, remember that every year an association must have an annual meeting. So if you haven't had one yet in 2020, and we recently conducted a poll, like I said earlier in our presentation, of over 200 board members, managers, and homeowners, and a large percentage of associations still have not had an annual meeting in 2020. We encourage you to reach out to our firm, and we can help you do a very quick and speedy annual meeting to tick that box so you make sure that you are in full compliance with Arizona law in 2021 by conducting your annual meeting. Okay, let's talk about some closing tips for board meetings, regular board meetings. If you're having a virtual meeting, a really good tip is to share the agenda on the screen during the meeting so that everybody can see where we are on the agenda. Another open meeting tip is if you're having an emergency board meeting. So an emergency board meeting is a meeting where you can't wait 48 hours to notice the meeting. The board needs to take immediate action. Sometimes this is done by email. Sometimes this is done telephonically or by Zoom. But basically you can't wait 48 hours to make a decision. So if you are having an emergency meeting for your association, make sure that you're taking meeting minutes. And make sure that at the next regular board meeting, you're reading into the record the meeting minutes for the emergency meeting, so that the regular meeting minutes will reflect what happened and what action was taken during the emergency meeting. Informal board meetings. I get this question all the time from associations, so I want to make sure we talk about this. The question I typically get is, what if our board just wants to have like a planning meeting? Or a forum where, we are discussing planning for, maybe a long-term capital improvement or a budget or finances or, a problem situation that we have. We're not going to vote at this meeting. We just want to talk. If a quorum of the board is present discussing association business, even if no formal action is taken by the board in the form of voting, it still must be an open board meeting. So planning sessions, if you're going to have them and you don't want to make them an open meeting, have less than a quorum of the board present to discuss the matters, and then that's your loophole to not have to comply with the open meeting law. Just a final cautionary reminder on open meetings and the open meeting law. Please remember that Arizona law is in favor of open meetings. And please be careful about using email or unanimous consent to make board decisions. A quorum of the board should not be using email to discuss or make decisions on association business unless it is an emergency. And remember that the use of a unanimous consent in lieu of a board meeting is potentially subject to legal challenge. I get very concerned when I see other, people in our industry and in Arizona and our community association industry allowing boards to use unanimous consent to make decisions in non-emergency situations. Really, there were 2 administrative law decisions several years ago that clearly state that this is a violation of the open meeting law, and we wholeheartedly recommend that associations not be using unanimous written consents. So making decisions by email or outside of a meeting using unanimous consents. Now, of course, as I mentioned earlier, if your board has an emergency and you can't wait 48 hours to make a decision, it is our position that you can make an emergency, decision by email, and a majority would be okay. Obviously, it would be best to try to conduct a meeting, quickly with the suspension of the 48 hours notice. So I'm really happy to see here today that we have 58 people live watching, which is awesome. Now remember that if you are watching live today, and you maybe have some other board members in your community who would be interested in watching this, be sure to go to our website after this presentation. It usually takes us a couple days, but we put the video on our website. And also you can come right back to Facebook Live, and you can click on our Facebook page immediately after the presentation and watch it, again, a recording of it live on Facebook Live. Okay, one final tip on board meetings before we move on to, talking about, making records requests and how associations should respond to that. What are some tips that I can give you on how to have a short board meeting? Well, number one, I can tell you that virtual meetings are significantly shorter than in-person meetings. So one silver lining of the pandemic is that although virtual meetings do take some planning, additional planning, the meetings are usually half the time of in-person meetings. I want you to be sure to check out our cheat sheet on board meetings, which Morgan from my office has posted in our comments section. We have some great tips on how to have a quick board meeting in that cheat sheet if you want to do a deep dive. But just two quick things I'd like to give you. If your meetings are excessively long, two best practices that I can tell you to use are, number one, have a timed agenda, and consider using a consent agenda. So if you have a timed agenda, how it would work is you back out your meeting and you say, okay, we're going to have a 45-minute board meeting this month. And on the agenda, you indicate that, okay, the meeting's starting right at 7 p.m. From 7 to 7:05, we're going to approve last month's meeting minutes. From 7:05 to 7:10, we're going to have the president's report. From 7:10 to 7:20, we're going to have the manager's report. From 7:20 to 7:25, we're going to have the treasurer's report. And then stick to that timeline. And your president is a person, that is the person that should be doing that, making sure that you stick to the timeline. And if you can't make a decision on something, you just push it to next month's meeting, and that will, add that to next month's meeting of the topics that you're going to be discussing. Another tip is to use a consent agenda. Having a consent agenda at the beginning of the meeting, maybe you could put approval of last month's meeting minutes. Maybe you could put approval of the president's report if the president does a written report and gives it to the board members prior to the meeting. You can usually lump a lot of different things in there, and you don't want to put the whole meeting in there, but of course, things that are routine would be very easy to put on a consent agenda. And how that works is you just make one motion to approve the consent agenda. You have a second, there's discussion, and then you vote. Now, sometimes somebody will say, no, I want to pull out the president's report because I want to ask a few questions. You could either do that during the discussion, or you could vote on that separately and pull it out. Okay, so I have just gotten the results of our Facebook Live poll, and this is a new feature that's so awesome that Facebook just put out. And we asked on our poll of the people that are watching here today, so we have about 58, we've had up to 60 people at one time today watching our Facebook Live. Has your association held a virtual meeting in 2020? 83% of viewers have said yes, they have held the virtual meeting. So that's really great feedback. Now, for those of you who haven't had a virtual meeting, the 17%, please make sure that you're checking out our virtual meeting cheat sheet. Think about calling into our First Friday free call-in this week on Friday, the first Friday of November. We're having our First Friday between 9 and 10 a.m. And you can call in and we'll give you some tips and advice and help you through, getting virtual for your meetings in 2020. Or if you even need our help getting the virtual meeting off the ground, we can do a training for you. We can sit in and help you with the first virtual meeting. But we really are suggesting that boards consider doing that, as I said earlier in the presentation. Okay, let's switch gears. We're right perfect timing. We're about 39 minutes into our presentation. Let's switch gears and talk a little bit about records requests. What are records requests and why do they usually occur in an association? So first, remember that associations are required to keep books and records, and that includes your minute books for your regular minutes and your executive session minutes, your financials you should be keeping for at least 7 years, your correspondence from homeowners, just bids, your check registers, your checkbook stubs. Obviously, all of these things are really important. Your budgets. All of these things should be kept for at least 7 years. And why 7 years? Because the statute of limitations in Arizona for breach of contract is 6 years. And so we like you to keep them for at least 7 years in case there's a lawsuit that might result as something that the association has done. Okay, so we have extensive keeping documents for the association. I mean, that's a requirement and a fiduciary duty, in my opinion, as part of our duty of care. Now, homeowners are allowed to see almost every document that belongs to the association. So the books and records of the association, generally speaking, are, almost everything homeowners are allowed to see. And so some questions that I commonly get are, can we see minutes of meetings? Yes, of course, owners can request to see meeting minutes, but they can't see executive session meeting minutes because obviously if they're not present at the executive session, they shouldn't be able to see the minutes. They can see budgets. Owners can request to see budgets. They can request to see check registers, all financials, bank statements of an association, correspondence files. There are some things that they can't see, and we're going to talk about those in just a minute. So when do we typically get records requests from owners? Is it owners that are all happy and think everything is honky-dory in the association? No, we know that, right? Typically, the most common type of person that requests a books and records of an association is somebody who's disgruntled with something that's happened in the association. Maybe they've received a violation notice. Maybe they weren't elected to the board. Maybe they're a former board member and not happy about how the new board is running. But generally speaking, I would say the typical records request comes from somebody who is generally dissatisfied with something in your association. Another category of persons that ask for records is somebody who has a personality type that they're a detail person and they want to check for themselves to make sure that things are in order in the association. So the high detail personality types also might be making records requests, and they may not necessarily be unhappy with how things are going in the association. So how typically do we get a records request from an owner? So in our experience, an owner will either contact the board or our law firm, or maybe send an email to the manager, ask for it at a meeting. They'll make a records request. Hey, I'd like to see these records. What best practices is that we request that owner to put it in writing. An email is fine. And then let us know specifically what documents you'd like to see. So sometimes you'll get a very large records request from an owner, or maybe you'll get a records request that is kind of disorganized and they're not really sure what they want to see and they're asking for large general topics of association's records. So what's an association to do when that happens? We highly recommend that you pick up the phone and call the owner and find out what's going on. In many, many cases, a management company or a board will ask us to help them with a records request from an owner. And maybe the owner is requesting, thousands of documents from the association and many, many years of documents. And so what we typically will do is we'll reach out to the owner, we'll attempt to contact them by phone, and surprisingly, it's like 100% of the time we usually do reach them right away. And I just let them know that I represent the association and we received your records request and we want to help you with whatever information that you want. But we also want to make sure that you're getting the documents that, are going to help you with whatever you're looking for. And so I try to get a little bit more background information, potentially about what they're upset about or what specifically they're looking for. Like sometimes we'll get a request for financial records for the past 20 years of the association. And that's really kind of unclear which specifically financial records that they want. And so, I may give them some pointers you may want to ask for, the year-to-date budgets, or you may want to ask for the balance sheets for the associations, and then I maybe want to ask, is there something specifically that you're looking for? Because lots of times the association doesn't have all the records 20 years back. And usually once I start talking with the person and we start discussing what they're upset about or what specifically they want, we typically can narrow it down to 10 to 20 pages of documents that they want. And what I always say is, if you want more information, you can come back if this isn't exactly what you're looking for, but I think this is where you're going to find the answer to your questions. And that saves a lot of angst from both sides, truly. And I'm a huge proponent of just shooting the documents to them by email and not, making a big production out of it. And so I recommend you doing that, even though we're going to talk in a minute about being able to charge a per page charge. Really, I try to shy away from that. If it's something that's quick and easy, and we can send it to them by email easily, we just get it to them quickly. And it's also a sign to the homeowner that, hey, we're willing to work with you. We're not hiding anything. We want to get you the documents. We want to help you find the answer to whatever you're looking for. Okay, so let's talk a little bit about what does the law say in Arizona. And this law is in the Condominium Act and the Planned Communities Act. And it specifies what information an owner can request. So first of all, the law says that any financial or other records of the association should be made available for examination by an owner or any person designated by that owner in writing as that member's representative. So books and records kept on behalf of the association are generally fair game for an owner. Now, there are a couple exceptions, and these exceptions kind of, interestingly, almost mirror identically the open meeting exemptions that we can go into executive session for. So anytime these 5 categories of information can be withheld from disclosure to a member if a board so chooses. So if a member requests these documents and the board doesn't want to give these documents to the owner, the board doesn't have to. So here are the 5 categories. Anytime you have privileged communication between an attorney for the association and the association. So opinion letters, settlement discussions, anytime there's an email regarding maybe a matter that the attorney is giving advice on, that is something that the owner is not entitled to see. Anytime we're involved in pending litigation, so any document pertaining to pending litigation would be off limits. Executive session meeting minutes, off limits. Anything pertaining to personal health or financial records of an individual member of an association, an employee of the association, or an individual employee of a contractor for the association. And last but not least, records relating to the job performance of, compensation of, health records of, or specific complaints against an employee of the association or a contractor that works for the association. So what are the kind of questionable areas where homeowners think, oh yeah, I'm entitled to see this, and the boards think, no, we're not? Let's talk about a couple of those questionable areas. So what if an owner, typically when you have a disgruntled owner, sometimes they want to contact the entire membership to state their position. And one of the things that they ask for is the emails and telephone numbers of the owners. Is that something that they're entitled to if it is a book and record of the association, if it's, on our computer program? Many association management companies have a computer program that keeps track of all that information. So it's our firm's opinion that individual personal telephone numbers, cell phone numbers, home line telephone numbers, emails, off-site property addresses, all of these are personal information pertaining to the owner. And unless the owner has specifically notified the board in writing that it's okay to disclose that information, it's our opinion that information should not be disclosed to an owner through a records request. Now, just best practices would be for your board to, at some point, clarify with your owners how they feel about this issue. And a good time to do that is at the annual meeting, on your annual meeting ballot. Maybe have a special, notation on your annual meeting ballot that says, I agree to provide owners that request my personal cell phone information, my offsite address, personal email address. I authorize the board to provide that information to a requesting owner. You could just have a yes or no, and then indicate that a no answer means that they're not authorizing that disclosure. And that's just a good thing to keep in our pockets and have in our file in case any owner should challenge that in the future. So another area that's kind of a gray area where owners think that they're entitled to review records, and sometimes associations think, no, you shouldn't see this, is when we talk about contracts for your vendors. So for example, like your management contract or your landscaping contract. Under the statute, which we just talked about, the 5th exemption is any records, pertaining to the compensation of an independent contractor or an independent or an individual employee of the association. It's our position that the contracts with your vendors should be given to owners if they request it. And here's why. Because if you want to read the black letter of the law, we would be entitled to redact or blacken out how much we're paying the vendor or how much we're paying the employee of the association under the statute. But the reality is that there's 10 other places the association member can look to find out that information. They can look on the budget, they can look in the check register. So why would we ever play hide the ball on that? And so it's our firm's opinion that boards should provide contracts for your vendors to owners if they request them. Okay, it looks like we have lots of good questions coming in, which is awesome. So some final closing points here on records requests by owners. Remember, the state law was amended about 5 years ago and says that the association's management company and board members cannot charge for making books and records available to review. So if you get a large records request, remember that you can't charge your time for putting those records together, and neither can your attorney. Now, some exceptions to that would be that, if the management contract says that the manager can, or the management company can charge the association for their time in putting that together, they can charge the association for that. But the association cannot pass that charge through to the individual member who's requesting the records. The second thing is if there's a large number of documents requested, the association has the right to charge 15 cents per page for copies of records. And that charge, is charged typically when the owner picks up the records. But again, as I said earlier, if it's a quick pop of an email to them, we don't charge for doing that. Typically, we just get it to the owner as quickly as possible. And then last but not least, when an owner makes a request for records, please be sure to calendar that you only have 10 business days to get the records to the owner. And if you have any large records requests or you feel that you can't get the records to the owner within 10 days, please reach out to me for guidance, and I'm happy to answer any questions that your association may have. Typically what we do is if it's a really large records request, like I said, we pick up the phone and call the owner and try to narrow down the categories of information that they want, if possible. And sometimes it's not possible, and we have to go through all the records that they want, and sometimes it's thousands of pages. And in those cases, you may need more than 10 business days. So we recommend that the board have your attorney immediately reach out to the owner and let them know that it's going to take longer than 10 business days to get the records to them, and give them an ETA, estimated time of arrival, for when the documents will be there. But remember, we can't be stalling on this. Maybe that's the case if we have to go get the records from storage or something like that. And so just remember that we do need to act in a timely manner when these records requests come in. And if you don't act in a timely manner, it is a violation of this law, and you could be sued or taken to the Arizona Department of Real Estate and have a specific complaint filed against your association for not providing the records. So please be mindful of that. We do have obligations to provide records to owners, and you know what? No problem. We should be giving the owners anything they want to see. We're not hiding anything. We're volunteers. We're doing the best job we can as board members, and owners should be entitled to see the records. And one little parting thought on this is, remember, the associations that communicate the best to their owners will have the fewest hassles. And so along those lines, if you're sending out meeting minutes every month after they're approved, and you're keeping owners up to date on your website with things that are going on in your association, you're less likely to get an excessive amount of records requests from your owners. Okay, now we're going to go into our question and answer period for our final virtual HOA Academy. It looks like we have a lot of great questions, so that's good. So I'm going to start right out with Rick Marine. Rick, great to see you today. Thanks for being here. Rick's a long-term client of our firm with an association in Scottsdale. Are the annual meeting requirements different if the HOA is still developer controlled? So that's a really good question, Rick. So many associations that are under developer control don't have what we would call a formal regular annual meeting. And our opinion, we always advise developers, if we should happen to represent a developer controlled board, that it's a good idea to have an annual meeting every year to let your owners know, what's going on in your community. But it's in our experience, developers typically do not have an annual meeting. Now, it's our opinion that once the association is post-developer control, the association must have an annual meeting, and we highly recommend that developers, while they're in declarant control, that they continue to have an annual meeting as well. Next question is from Joan Mass-Doyle. Are the annual meeting requirements different? Looks like I got those transposed. Sorry about that. So that was Joan's question on the annual meeting being under developer control. Sorry about that. Rick's question is, what are the top 3 things our HOA should do to run like a business? Best practices. So the top 3 things I would say, number 1, communicate to your owners frequently about what's going on in your association, any special problems that you're having, your financials, what's going on with your financials, especially during COVID, communicating with them about what's going on. So number 1, I would say communicate. Number 2, reach out to trusted advisors when you have questions. The associations that don't run like businesses and that have a lot of problems, they're not attending seminars like this, and they're not asking their lawyer questions when problems come up, and they're not, consulting with a reserve specialist or their management company or their insurance agent to give them advice. So I think the second tip would be reach out to your trusted advisors. Then the third tip, just along with that, make sure that you're continuing to, get education, read your documents, carefully follow your financials to make sure that your association is financially in good shape. That would be the third tip. That would be a really good seminar class for future seminars. We'll have to keep that in our back pocket for, the future spring HOA Academy that we're having, maybe having a class on how to best practices for running association business. Let's see, the next question is from Stephen. Can we vote through email and make decisions, but then report it all in our next open meeting and ask for responses? So Stephen, great question. We touched on this just a little bit today, and just to clarify, it's our firm's opinion that the board really should not be making email decisions outside of a board meeting unless it's an absolute emergency and there's no other way for the board to meet to make a decision. If you have made decisions by email and you're concerned about it, of course, one way to rectify that would be to reaffirm the decision at an open board meeting. But again, best practices would be conducting your association business at an open board meeting. And the only time to be using email would be if you have an emergency situation. The next question is from Lynn. I was told that if we don't have enough people running for the board, that the state would take over our association. Is that true? No, that's not true. Unfortunately, that is a problem that we see frequently in associations where there's difficulty getting board members to run for the board. And on our cheat sheet entitled Annual Meetings, we have some tips on how you can try to get board members in your community. Some tips that I can give you would be to reach out to people on committees who are serving in your association, reach out to people who have come to board meetings and who have shown interest in your community, reach out to people who are maintaining their property really well, because obviously they care about maintaining their own property. Reach out to people who may have special expertise, like somebody who owns a landscaping business, or somebody who's an attorney or a CPA or an insurance agent. Those people all could bring something unique to your board. Now, let's say you don't have anybody who's running for your board, right? And you've had a board that's been serving for like 10 years and people want to move on. How do we handle a situation like that where we want to get out, right? We've had enough time serving on our board. This isn't a life sentence. How do we find new people? So use the suggestions that I gave you about, people who are in your community who you think might be a good fit. Another suggestion would be our firm has successfully written a letter to all owners explaining the legal consequences if you can't have people run for the board. And so that may kind of go along with your question about the state taking over. Now, of course, the state would never take over your association under Arizona law. But what my letter says to owners is, okay, we can't find anybody to serve on your board. And if we can't find anybody to serve on your board, a likely outcome will be that a lawsuit will be filed in Superior Court, and a request of the lawsuit will be that a receiver is appointed to run the affairs of the association. And, we've seen this happen in associations, other associations, unfortunately, not many, But the first thing that the court does is appoint a receiver, and then the receiver runs the affairs of the association. The first thing that they do is ask the court to levy a special assessment to pay for their fees. And so it can be very expensive for associations that are in this situation. So when I send my letter explaining that, hey, this could result in a special assessment to pay for the receiver, and being on the board is not that large of a commitment, it's just one meeting a month, and we don't always meet every month. Every time I've sent that letter previously, we've had people volunteer to serve on the board. So if your board's in one of those situations where you can't find anybody to serve on your board, make sure that you're reaching out to me and I can help you with a letter to get people to run for the board. Mark asks, what does the law say if a quorum of the board meets outside an open board meeting and doesn't give notice and discusses board business? So the law says that that would be, a violation of the open meeting law. It's bottom line. And, if you can prove that that's occurring, then you would have, legal action against your board. Okay, Bob Lehman, good to hear from you, Bob. Hope everything's going well. Hope you had a good time on your trip. What is the legal time frame to supply multiple year meeting minutes that have been requested by a homeowner? Okay, good question. So I'm not sure what you mean by multiple year, but I'm guessing like a decade or something like that. Really, it just depends. I mean, if you have them all in an easy to access server, and they've all been saved and you can just pop them all out in emails, I think you should be able to meet the 10 business day requirement to get the documents to the owner. But if you have to go to storage and, find documents, you should just communicate to the owner what reasonable time frame you can get the documents to the owner, and maybe give them the stuff that's easy to get to them. Maybe the last 5 years are electronic, and then say, hey, we've got to go to storage and it's going to take us 30 days to get that to you. Just communicate, because if an owner tries to sue you for not giving you the documents, showing the judge that you responded in a prompt manner, that you explained to the owner why it was going to take longer, and that you gave the owner the documents that were easily accessible, are really going to go a long way in showing that you haven't violated the law on this. One other question that I want to mention here, because this is, a question that I get often, is what do we do if we don't have the records that the owner is requesting? Maybe a board changed, maybe there was an accident, and paperwork was damaged through a flood or something. We've seen all of these things happen. Just communicate directly to, you may want to talk to your attorney, because, there may be some legal implications of you not having records. But the bottom line is you're going to have to tell the owner, we don't have the records. They don't exist anymore. And if they don't exist, you just have to tell the owner, we don't have them. Okay, the next question is from Julie. Should the HOA post minutes of the committees on a website, such as budget committee or compliance committee minutes? Yeah, I think, of course, anything that you can post on your website to communicate with your owners what's going on in your association is great. The only exception would be, executive session minutes. They shouldn't be posted. It's our opinion they shouldn't be posted on your website. They could be posted in a password protection area for board members only. Some question I get is, if we're putting all this information open on the internet, are we exposing our association to having this information, being reviewed by non-owners? Possibly, and that may, you may want to have the minutes in a password protection area. The next question is from Michael. Are owners entitled to inspect the letter of engagement from the board's attorney? Yes, I would have no problem with an owner inspecting our letter of engagement. It's not attorney-client privileged, in my opinion. And I think it would be fine to inspect that, and I would provide it if an owner wanted to see it for any association that I represent. Next question is from George. If an owner submits a request, can we scan or email to the owner? The answer to that is yes. Now, of course, if the owner wants a paper copy, then you could charge the owner the 15 cents per page, and you'd have to give it to that owner in that way. Okay, next question is from Jack Martino, one of my very favorite board members in the West Valley. Great to hear from you, Jack. Record requests have been submitted to the management company and ignored. Do you have suggestions as to how to proceed forward? Okay, well, there's kind of two parts to this question. So let's say that you're a board member and you can't get records from your management company. And I'm not talking about any specific case here. I'm just saying in general. In general, my feeling is that signifies that there's a very serious problem in your association, and you need to consult with your legal counsel to make sure that the management company is giving board members records. Now, let's say that you're an owner and the owners are trying to contact the management company and the management company is not giving the owners records, and these aren't records, that can be withheld from disclosure. In that situation, the owners should be notifying the board, and the board should be telling the management company you need to release, the records to the owner in a timely fashion. And really, it's just kind of an example of possibly how a management company isn't following the terms of their contract, and it may be time for the board to have a meeting with the management company to discuss their performance and possibly consider moving on to a different management company. Next question from Julie. In your opinion, does a Black Lives Matter sign fall within the political sign category, and can a resident keep the sign, or is this just for actual campaign signs? That's a really good question. With the election today, we're seeing political flags, lots of political signs. Many owners still have, statements, Black Lives Matter flags or signs or homemade posters on their property. I think we really need to look at it on a case-by-case basis. Of course, the political signs and the political flags need to be removed by Saturday, as I said at the beginning of my presentation today, under Arizona law. On the Black Lives Matter signs, that's a different signage, and you'd have to look at what your documents say to determine whether or not that type of sign is allowable. I think you also have to take into consideration what's going on right now in our country. And, we've had a situation recently that we read about online where an association asked an owner to remove a Black Lives Matter sign. And the owner went to the news media, and the news media did a negative story on the association. And so I think if your association is evaluating this issue right now, my recommendation would be I would let those signs sit likely through the end of 2020 and reevaluate the first quarter of 2021. I think we all can agree that there's a lot of political unrest right now in our country, and we can all agree that this is the type of a situation where an association could receive negative press if they asked an owner to take it down. And so our opinion is, to allow those signs through the end of the year and reevaluate it in January of 2021. Next question is from Mark. Is it legal for the management company to destroy the recordings of virtual meetings? It really just depends. It depends on what direction they're being given by the board. Now, some virtual meetings, like if you're using Zoom, the Zoom cloud only holds meetings for 30 days. So unless you actively save the Zoom recording on a network for your association, it's going to be automatically destroyed. Most associations don't keep recordings of board meetings indefinitely. Sometimes they just use them to make the meeting minutes, to help them fill in gaps on the meeting minutes. But, with the virtual meetings, things are changing. And so maybe virtual meetings are something that boards will be keeping more often. So it really is up to your board. And the board directs the management company how they want to handle keeping the virtual meetings. If they want to, keep them indefinitely, have a destruction policy. But the law does not require an association to keep a copy of a virtual board meeting. The only exception to that would be is if an owner's requested that the meeting be taped and the board opts to tape the meeting, then the board would have to keep a copy of the virtual meeting to provide it to the owner. Okay, the next question is from Audrey. Can owners see bank statements? Short answer on this would be yes. An owner can see a bank statement of the association. Now, oftentimes boards get upset when I say that because they say, well, they'll have our confidential information, our bank account numbers. If the board feels uncomfortable providing that to the owner, you can always redact that information, blacken that out so the owner wouldn't have that specific information. Next question is from Melanie. Assuming an eligible voter list is created prior to an annual meeting, if an individual requested this record, would you suggest it be provided? So yes, of course. There's a couple lists that owners can request from the association that wouldn't be personal information that's not protected. So an owner's list, so a record list of everybody who owns a property in the association would be acceptable to request. A list of the owner's addresses in the property would also be okay for an owner to request, and the association would be required to provide. An eligible voter list would be a list of owners who are able to vote because they're not delinquent. Honestly, I really don't see many associations creating that list. What I do see is a delinquency list. And so I'm sure you're wanting to see this before the annual meeting so you can determine who can and cannot vote. What I would recommend is, typically I will say you can have the list, but we redact the names so you can see how much is owed on how many different lots in the total, but we don't have the owner's name listed is typically how we handle that. And that should be something that you should just be able to request before an annual meeting. That's just a printout that the management company should be able to do. Okay, a few more questions we have before we sign off for today. Question from Kim: can ARC records with personal homeowner information be released to a designated rep, not a homeowner? So yes, a short answer would be if an owner places a notice to the association, something in writing, saying that a designated representative, like their attorney or their realtor or their family member or maybe even their tenant, is entitled to review records, that person can make the records request to the association. So an ARC record, an architectural review form record, would be something that is discoverable and that an owner would be, or a designated agent would be able to request. This is kind of complicated, Kim, so I would just encourage you to call into our First Friday free call-in this Friday if you want to discuss this further. And again, you can call our office, anybody who's listening here today or anybody else who's a board member or manager in an association. You can call our First Friday, which is this Friday, and you call between the hours of 9 a.m. and 10 a.m. to our main line, which is 602-241-1093. And one of our Mulcahy attorneys will answer one question at no charge. So I encourage you to do that, Kim, and anybody else who maybe thinks of a question after this Facebook Live today. Last four questions. Our first one is from Rick. What is a board's responsibility when a resident insists on paper copies of records but refuses to retrieve them when the copies are available for pickup? Oh, Rick, I feel you on this one. I had a case many, many, many years ago where an owner requested 8,000 copies of documents and then refused to come and get them or pay the fee for the copy charges. So what we typically will do is we request the money up front for the records before we make the copies. So they have to pay us up front. And then we make the copies and then they can pick them up. And usually requesting the money up front, will ensure that they'll show up. If they don't want to pay the charges up front, you can tell them that we will have the records available in a socially distanced conference room at our attorney's office or the management company's office, and you can review them. If after you review them, you can decide if you want to have copies made and then give us the upfront money of the copies that you want to have made. The third to the last question is from Karen. What information should or shouldn't be posted on social media by the association? Really good question. A lot of associations are posting information about board meetings, about, updates regarding the association, if the trash date changes, when your meetings are. Some post meeting minutes, some post information about community events. It really just depends. What shouldn't be posted on social media would be crazy rants, where people are fighting. Those really don't reflect well on the association. Things that would be confidential, like an attorney's opinion letter or status of a lawsuit, things like that. Okay, the second to the last question is from George. We have a question for our property management and want to meet with them. Do we need to let all the owners know? So good question, George. So if less than a quorum of the board is meeting with the management company, it doesn't have to be an open board meeting. If a full quorum of the board is meeting with the management company and you're discussing association business, it can be possibly an executive session, but you would still have to notice it as an executive session. if you're discussing one of the executive session topics like their job performance or their compensation. Or if you're not discussing a topic like that, then you would have to do it in an open board meeting if a quorum of the board is present. Okay, the last question is from Julie. Virtual meetings, how do we track who is in attendance? Usually we have a sign-in sheet for owners to sign in. Great question, Julie. So remember, for regular board meetings, you don't have to keep track of everybody who, participates. It's not like the minutes have to reflect any non-board members or special guests who are there. So your minutes don't have to reflect every member's name who attends a regular board meeting. But if you want to just keep track of who's there, what you can do is have them indicate, well, their name should be in like a Zoom column, their name should be listed under their photo on the virtual meeting. You also, if people are dialing in, sometimes people don't have their name or they have like some sort of a nickname. You could private message them, have your manager, whoever's managing the functions of the meeting, private message them and ask for their name and their lot number so you know who's listening into the meeting. If they refuse, the administrator could, remove them from the meeting, but try to, work together on this. If somebody's dialing into the meeting, you may need to call them out specifically in the meeting and ask for them to provide their name and unmute them because they won't see the message function if they're dialing in. So I hope those are some good suggestions for you on how you can determine who's in attendance at your meeting. Okay, so just some parting words for our last virtual HOA Academy for 2020. Thank you so much for participating with us through the pandemic times. We had several classes, 2 classes, in March, April, and May, and June and July. And then we started our fall virtual HOA Academy and had 5 classes this fall. And we really appreciate all of you joining us to help improve your association and to get your questions answered. We'd also like to say thank you again for the partnership with neighborhood services from Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, Tempe, and the town of Queen Creek. Without all of you working together to make our communities better, we wouldn't be able to put this free programming together for the many residents in your cities and the many board members and the management companies that service the residents in your cities. So thank you again for partnering with our firm to provide these free classes. Remember, if you are a board member, manager, or homeowner listening to these classes today, be sure to check out your city's website because it contains a wealth of great information for your communities. And I know that all the neighborhood services departments put a lot of time and effort in providing information for their homeowners on these different websites, so be sure to check those out. And I'm just really proud and pleased to let you know that we're going to be partnering again with many of these same cities to provide a free virtual HOA Academy again starting in January and likely through June of 2021. So I encourage you to check out our webpage. Make sure you're checking our Facebook page to determine when those classes are going to be released. And we look forward to seeing all of you again soon. When we start up our 2021 classes. And just a brief reminder, if anything happens in the next 60 days that you need to be aware of, you have our guarantee that we'll be talking about it on Facebook. We'll be talking about it in our Mulcahy memos, which we send out by email. Be sure to sign up for those by going to our website at mulcahylawfirm.com. And we'll also get on to Facebook Lives if there's any really big developments. I think we all can anticipate that 2021 is going to be a big legislative year for associations, so we'll be talking about that in January too as our legislature reopens. As you know, in 2020 we didn't have any bills pertaining to associations, so 2021 definitely will be a big year. So thank you again for being here today. We appreciate you sharing your time with us and learning more about your association, and we wish you the happiest of all holidays coming up in November and December. And we look forward to seeing you again soon. Take care, everybody. Be safe.
This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler, we're in this together.
Town of Queen Creek. We're in this together.
Hi, this is Jamie from the city of Scottsdale with my daughter Jocelyn. Whether you're working from home or doing kindergarten from home, we want to remind you that we're in this together.
City of Tempe. We are in this